Hi, it's Richard Geller. It's not often that there are rules and laws that really favor the borrower, but one example is part of RESPA, the Real Estate Settlements Act. And there's a part of that that applies to servicers called the Servicers Act that was passed in 1990. Now, what this does is it lets you get somewhat of an edge over your lender when you're trying to do a loan mod. And here's what you do. You file a qualified written response. And I have a lot of questions about what that means. Well, when you file a qualified written response, what you're doing is you're writing a letter, and you're either questioning the charges and the way your loan's being serviced, or you're contesting. You don't have to do both. You can either contest or you can question. And what you do is you write a letter with your name and address and your loan number so they can identify who you are. You can put a title, qualified written response if you want to. And you ask them about, something about your servicing that you're questioning, about your charges or about interest rates or how it's calculated or whatever. And you put in you can also contest and say, I don't think this is right. You can do either one or the other or both, but just do one. Now, here's what happens. When they get this letter, they've got to stop reporting delinquencies to collection agencies. They have to stop saying bad things about you. They have to stop everything, and they have to investigate. How long? They have 60 days to investigate. They have to do a legitimate investigation. And then they have to fix things up. We have found a lot of people have said that if they're doing a loan mod or a short sale, that when they do a qualified written response, what they get is a huge advantage over the lender because the lender oftentimes finds out everything's all screwed up and they're willing to deal. Why should the lender deal with you if they've screwed up? Well, the Servicers Act has damages that it allows consumers. There's what they call statutory damages, there's attorney's fees, and there's costs. That means that if you have a lawyer go after them, that they're going to have to pay your lawyer, they're going to have to pay all the costs, all the court costs of photocopying, and even the postage. And they're going to have to pay damages. Now, most of the courts have construed damages to mean emotional distress. Not all of them, but most of the rulings. So the damages could be quite significant if you've been up, nights and depressed and you've had to go get psychological help. And there's terrible things that have happened to people as a result of these lenders screwing up. So it's not inconceivable you could find a lawyer and press for significant damages. But even if you don't, you could use that as leverage to get a much more favorable loan mod or short sale, could you not? Many people have. Many people have gotten lenders to waive deficiency judgments on short sales where they would otherwise be entitled to them. Now, there's some technicalities on this. It's not that complicated. I'm not a lawyer. I suggest that you get legal advice for yourself and that you don't listen to me because, I'm some guy on the internet. But I have come out with my TILA Secrets course, and I hope you get the course because it gives you a really complete education on Truth in Lending Act and various TILA violations and all that. I will say one thing, it is not a way for you to audit your loan to see if there's been TILA violations. You'll know if there's probably been TILA violations, but this is all the education that you need, and auditing TILA is very, very sophisticated. I leave it to the lawyers. But I want you to get your complete education on the Truth in Lending Act and RESPA and all of what it means to you and the rights that you and your clients have. And I hope that you'll get my TILA Secrets course for that information. Richard Geller will talk to you soon. Thank you.